Can you challenge a 20-year-old separation agreement? What New York courts consider. A separation agreement signed decades ago can feel untouchable, but New York law does not always treat it that way. Courts generally favor finality in marital contracts, yet they sometimes revisit even a 20-year-old deal when deeper issues existed at the time of signing. These cases turn on fairness, the fiduciary duties between spouses, and what courts describe as the original sin behind the agreement. New York's heightened scrutiny of marital contracts comes from the fiduciary bond between spouses, which requires full financial disclosure, fairness, and good faith. Because of that relationship, a separation agreement is not reviewed like a business contract. Courts look beneath the surface, asking whether the deal was just and fair and whether it ought to be enforced decades later, especially in places like the Bronx where many couples historically signed agreements without meaningful legal guidance. The legal question is whether the agreement was truly regular on its face or whether it stemmed from a breach of fiduciary duty at the time it was signed. Challenges often involve agreements formed under circumstances that would not meet today's standards for disclosure. This context becomes even more important when the agreement has governed the parties' lives for 20 years. Yes, under the right circumstances, you can challenge a 20-year-old separation agreement in New York. Courts will not reopen an old contract simply because someone regrets the deal, but they may intervene if the agreement was shaped by fraud, concealment, misrepresentation, or unconscionability. These are the rare situations where time does not fully shield an agreement from scrutiny. Fraud, concealment, and misrepresentation frequently arise in Bronx cases involving assets or income never disclosed when the agreement was signed. Undisclosed property interests, hidden rental income, unreported small business revenue, and cash-based earnings are common patterns that surface years later. Evidence may emerge through property tax searches, community conversations, or inadvertent disclosures within families. Because many Bronx businesses historically operated informally, the opportunity for concealed income was often significant, and courts recognize this when considering long-ago agreements. Unconscionability can also justify setting aside an old agreement. Procedural unconscionability focuses on how the contract was formed, including whether one spouse lacked independent legal counsel, faced duress, or had significantly less bargaining power. Substantive unconscionability examines the terms themselves, whether the agreement was so one-sided that no reasonable person would have accepted it. Generally, both forms are required, but if the terms shock the conscience, substantive unconscionability alone can be enough. This becomes especially important after 20 years, when memories fade and witnesses disappear, leaving only the written terms as evidence. Time-based defenses make these cases difficult. The statute of limitations for contract claims is 6 years, which makes a 20-year challenge appear impossible. But the fraud discovery rule allows a claim within 6 years of the fraud or 2 years from when it was discovered with reasonable diligence. This rule is often the legal lifeline, though the challenger must show that the fraud could not have been discovered earlier. A defending spouse may argue that public records or other information were available and should have been found sooner, making concealment a critical issue. Ratification is another barrier. A spouse who accepted benefits over time may be viewed as having approved the agreement. To overcome this, the challenger must show that the ratification itself was tainted by fraud, meaning they accepted benefits without knowing the true nature of the concealed asset. Laches also poses a substantial obstacle, as the defending spouse may claim that the long delay has caused prejudice due to lost evidence or fading memories. Here again, the challenger must tie the delay to the other spouse's concealment. Despite the hurdles, New York courts do not dismiss these cases lightly when evidence of fraud, concealment, or profound unfairness exists. Older agreements shaped by serious legal defects may still be vulnerable, even after decades. If you believe your long-ago separation agreement was shaped by fraud, hidden assets, or unfair circumstances, guidance from a knowledgeable lawyer is essential. An experienced attorney can evaluate whether time-based defenses can be overcome and whether the agreement's original flaws justify revisiting it today. The team at Juan Luciano Divorce Lawyer continues to help clients navigate these complex challenges from their office at 187 East 163rd Street, Bronx, New York, 10451, and can be reached at 718-519-8336.